Hello, and thank you for watching. This is Tasha Simmons, Florida family lawyer and Florida Supreme Court certified family law mediator. I wanted to do this video series to help those of us who are faced with the task of what's called mandatory disclosure, or the financial disclosure process that is sort of built into family court. If you are, a litigant in a Florida case, whether you live in Florida or not, and you just started a family court case, maybe you were just served, maybe you're the one that just filed, or maybe the case has been reopened, you're going to find that once the respondent is served, then you'll have 45 days to exchange a list of financial documents. So this video is being made because a lot of us have a lot of trouble with this. And I want to be of assistance to the public generally. If you already have an attorney, you can still watch the video. It's no problem. If you represent yourself, you can still watch and benefit from this video. And if you are one of my just special, beloved, and valued clients, this video is for you primarily, just so you can come back to it if you have any questions. And that way, when we get together, we can make the most of our time to handle your unique questions. But I'm just going to use these videos to sort of answer questions that come up all the time. So I'm not a broken record. And then if you need a broken record, you can just come here. And then when we talk, we can go further. We can get deeper into your case and what needs to be done next. Okay. So mandatory disclosure, what is it? It's a fancy way of saying you are required to give your ex just to open up your financial books to them, which, I mean, it's not funny, but I'm sure it's cruelly ironic when you think about it. Nobody likes doing it, right? I mean, I don't like asking for it, but it's required. It makes the family court process more efficient, or at least it aims to, by just saying, listen, no one has to do discovery requests. You don't have to send a paper asking for this or asking for that. We already know when we're in this part of the case, both sides have to hand over A, B, C, D, E, F, and etc. So I'm actually going to walk you through A to Z. Well, there's not 26. There aren't 26 categories, but there are a few. So what we're going to do, okay, is I'm going to walk you through each and every one of these categories. Now, if you have documents that pertain to that category, we'll talk about how you can gather them, or typical issues that come up with them. And if it doesn't apply to you, you can skip that video. All right. So again, when the respondent is served, that starts a 45-day window. All right. And we don't want to get to day 46 and we're not in compliance. Alrighty. So let's get into how you comply and what happens if you don't, and then we can move on to the day one video, which will be the financial affidavit. But how do you comply? Your attorney may send you a document called Certificate of Compliance with Mandatory Disclosure. Okay, it's a form that serves two purposes. It's a list for you to know, hey, these are the things that I have to gather and give to my attorney so they can give it to the other side. Or if you represent yourself, you would be sending this to the other side or their attorney. Okay. After you have gathered everything that you do have that's on that list, you're also going to sign the list and file it with the court to let the court know I have complied with this requirement. Okay, so it's very important that when your attorney, or if your attorney sends you that form, or if you download it from flcourts.org, that you go through it, alrighty? And that you sign it truthfully after you've given everything over. Now, if you do not file your certificate letting the court know that you complied, and if you haven't complied, then as early as day 46, the other side can reach out to the court, file a motion, and ask the court to compel or force you to hurry up and turn them over in 10 days. Okay, and the court has to, the court has the authority to do that. They don't have to schedule a hearing and send you a notice and say, hey, be in court this day. We're going to rule on their motion to compel. Okay, when you haven't given over anything, they can do that. They can get the 10-day order, no hearing, no nothing. Now, if you've given over some things, but not everything, or you haven't filed a notice of compliance, a certificate of compliance showing the court that you complied, then they can file a regular motion to compel, and it could be the same outcome. The court can say, listen, you have 10 days, you have 5 days, you have 21 days, and possibly because they had to come here and force you to do it, I'm also going to order you to pay their attorney's fees. We don't want that. What else do we not want? We don't want the court to look at you like the person who doesn't want to follow the rules, right? While the other side is over there looking like a saint. That tends to happen. It can happen. Judges are human, and family cases are heard just by judges. There's no jury. Okay, so what you don't want to do is give the one person who's going to be making all the decisions on your case a bad taste in their mouth about you. All right, so do what you can. If there's anything you can't do, the important thing is just communicate. Communicate with me if I represent you, of course. If I do not, don't. Communicate with your lawyer. And if you are self-represented, then file a motion asking the court for more time. They can grant it, maybe not, but at least you're appearing responsible, knowing that this is something I have to do, and I know when it has to be done by, and I am responding to that requirement. I'm responding to that obligation instead of just letting it sit there and looking like I'm not complying. Alrighty? So we are done with the introduction. All right, let's move on to day one. We're going to do your financial affidavit.